Bill Ray, I think I am next on the agenda here. But before I speak, I would like for we have the city clerk of Harrison here, Jeff Pratt, and we were talking during the break about Luke's comments about getting notice of meetings, and Jeff had I thought a very interesting and unique insight on what folks do here.
Well, the comment that I wanted to make, that I made to Luke and anybody else, that when you're dealing with FOIA and talking about notifications, I deal with the other side of that. I get the requests a lot and process those. One thing you might want to consider is not only being added to a list where you're receiving all the meeting notices, but also the documentation. We have two separate lists. We have people that want to know anytime the council is meeting, that the city's having any kind of meeting, and they're on an email stream that goes out. We also have another email stream where people want to be copied in on all documents, all data going out to the council member, to the governing body. So if you're dealing with a school board or city or county government, you may want to get those documents that are going out to those members prior to the meeting so that you would have a better idea of what's going to be discussed rather than just the simple agenda. A lot of times just a statement on an agenda isn't really do justice to what that topic's going to be. But okay, that would be one of my suggestions.
What does it feel like to have some of these requests?
You know,
Bill Ray asked, what does it feel like to have some of these requests from the city government perspective?
From the city government perspective, FOIA, it really is a vital and a very good tool to the citizens, to the public. From the city side, it's really not an issue 99% of the time. But just like anything good in our world, you will have individuals that will abuse it. We'll have, there's what I would consider frivolous requests that do nothing but tie up taxpayers' time, money, government, officials' money, just trying to research. I've been doing this for 13 years, and I will get some requests every once in a while where it's someone that's just mad at the city and they want to use it in a punitive basis. I want to know every time, I want a copy of every report where there was a person from Missouri stopped over the last 10 years. Well, I mean, that's fine, and I understand you may be trying to generate, and look something up, and it may not even be a police thing. I've had, anytime a person was referenced in a meeting over the last 10 years, that's fine, and we'll do it. But when you ask for the same request 2, 3, 4 times, that starts to get a little redundant. They're asking for the same document multiple times. To me, that becomes a frivolous request. And I was mentioning to Luke in the break, the other thing that I struggle with sometime in complying with FOI, but we do it, is companies that use FOIA to gather data to turn around and sell it to people. I may get an FOI request that wants very detailed documents put in a very detailed spreadsheet for them. They want to receive their documents in a very set way. Well, I don't have that report. It's my understanding I'm not required to generate that report. I can give you the data and you put it in your own spreadsheet, but sometimes I go back and forth with companies on that kind of stuff. But like I said, 99%, it's a wonderful tool for the public, and I would encourage people to use it anytime you've got anything you're needing. Sir.
How many hours would you say in a month do you devote, how many hours a month do you devote to dealing with FOI? Because some of those requests can take up a lot of time.
It really depends. There have been, this last month, I've probably spent, I don't know, 5 or 10 hours in the last month. There are months where it may consume everything I've got for that month, just depending on how punitive. Every one of those have been just some, I've got people sitting in jail that's just asking for silliness, and you comply with it, and you do the best you can. But it's funny how they understand you got to reply in a timely manner. They get that one down right fast, but it's like this arm list of stuff. And so we do have to explain that we can only do so much, and we'll get it to you as quickly as we can get it. But sometimes that 72 hours is tough.
Yeah.
But anyway,
Thank you.
You bet.
Well, I think that's a very unique perspective, and but one that our counties, our cities, and our school boards deal with. And I want to make a couple of comments on that. Your point on this punitive aspect is also concerning to me, because sometimes it's a fine line, and we need to err on the side of producing records, obviously. But I encourage anyone in this room or anyone listening, the thousands of people we have listening out here, never make a punitive request. Don't do something just to keep somebody busy, because what's going to happen is some of the colleagues of Senator Sullivan's going to say, look, we're going to have to cut back FOIA. We're going to have to create another exemption. We're going to have to create another exception, and it's going to hurt those of us who have good faith in mind. So I encourage people never to do that. I've counseled several people. No, don't do that. We don't want frivolous entering the vocabulary from our side, because believe me, we have government saying that we're filing frivolous. Recently I'll be talking about a case I'm involved in where they said I spent all day in court, yet it was a frivolous lawsuit and they wanted attorney fees from me. But as you commented on, we do have the right to records, but your issue about businesses wanting a detailed report, that's covered under FOIA too, and they can charge you for that report if they choose to say, look, I'll produce you a report, but we're going to charge you an hourly rate for it. So I think that's a good protection. Although recently, in a case involving a records request that I made on the Fort Smith Public Schools, they started that noise with me about they were going to charge me for records, and it had nothing to do with a report. And I thought it was just an excuse in trying to intimidate, and they're not going to intimidate me, but they may intimidate someone if they start, well, you can have these, but we're going to charge you X amount, because that's not what FOIA is about. We're entitled to this information, and we've got to, it's a fine, delicate balance. With that said, I want to talk to you about the application, I guess I would say, of FOIA in lawsuits, because when Senator Sullivan creates laws, they have practical effects, and FOIA in 1967, Governor Winthrop Rockefeller, we got our Sunshine Law in 1967. It's been known as the strongest law across the country, although I think recently it's been weakened somewhat, particularly with regard to meetings. But that's another subject for another day, and that's why it's important that we work with our legislators to strengthen FOIA And we're going to be, and we did last time, we're going to be looking to define what a meeting is. And we're excited for the next legislative session. We built some foundations in the last legislative session, and so we'll be defining what a meeting is. That'll be good for the citizens, and it'll be good for school boards and city bodies to know, can I talk to this person? Can I talk to this, can two school board members talk to each other about an issue that's coming before the board? Can three? Where is that line? So we hope to define that. All right. So I want to talk to you first of all about the Kristen Kitchens versus the City of Fort Smith case, which is a recent case. As you know, this was about and it's still going on. It is regarding a sales tax extension in Fort Smith involving millions upon millions of taxpayer dollars. What happened, they were considering basically how to allocate these sales tax funds, taking 1% of revenue coming in and how to allocate it. And I'm not going to get into the weeds with the details, but in essence, there was a decision as to how we wanted to allocate that money. One of the proposals did not involve parks and recreation. The other one did. So the city administration sent out a memorandum regarding, in essence, two options that they were going to set for a special election. And a special election that was going to be set in 3 months. So you can see I FOIA'd the documents relating to this matter through the Freedom of Information Act. And one of the first documents I got back was a memo from our city director, our city administrator, I'm sorry, to the board of directors talking about how since there are differing opinions among the board members, and since we do not want this topic to be bandied around in such a way that could deflect from the ultimate decision of the board, there are three options to consider. Well, when I see that, that's exactly what we want happening in our meetings. We want school board members, we want city administrators to be making the sausage in front of us. We don't want them talking on secret text message and email chains and at the back of McDonald's about the process to reach a decision. So what we had in this particular case was what the Supreme Court said could not happen. A decision being made outside of the governing body, outside of their meeting. So what happened was that on the options, through a mechanism of controlling their agenda, they have a process where, maybe they don't want to hear a particular, don't want to hear this issue this month, so they kick the entire thing off and they control their agenda and they set it for next month. Well, what they did here is one of the directors asked that we had two competing options. We had option A and we had option B. So through their process, what they can do and what they did do is he called up the city clerk, who then polled every single board of directors. Do you vote for option A or do you vote for option B? And by a count of 5-2, they voted to do away with parks. You and I didn't get to see that discussion. That discussion occurred through a straw man, through the city clerk polling every board member. So what happens is, they get to the meeting the next week, and I'm watching it, and I'm hearing these conversations that start to occur about, for example, Director Settle, one of our board of directors, he started talking about, I know it got pulled, and I'm not trying to amend it and put it back in because I know the board doesn't wish that, but I wish we could have had that in there. And I'm scratching my head, and I start scrolling back, and I'm like, when did they talk about that in this meeting? And then another director, Director Good, he goes through this conversation in talking about the parks money, and you know, so my wife's asked me, are you guys serious about doing this, something about the consent decree, or are you about playtime? And then he goes on to state, so it was a hard decision, but if we're serious about making this vote, then let's make sure we have the money we need to get it taken care of. So he's talking about making a decision, and again, I'm asking myself, where did this decision come? So, long story short, I FOIA'd the documents, got the documents, and I found out about this mechanism where the board had been polled the week before. And to me, and I think according to the law, that was a secret vote. In Fort Smith, we've got a sewer issue that's costing close to $1 billion to get fixed now. And so they're deciding how to divvy up the taxpayer dollars. So it's a huge issue. And one that our city said that, well, we can't talk about this consent decree issue because the various government entities have a protective order. So only the citizens can't hear about this. They said that for literally 4 years until I called their hand on it. I FOIA'd the protective order. We got the protective order, and it said it was subject to FOIA. So in other words, all of this should be open. So it's in that spirit. So when I found out these things, we filed this lawsuit. Professor Steinbuck, my partner Stephen Naparano, and myself, we spent the whole day battling the city over should FOIA take precedent over you setting your agenda when it amounts to polling of the board. They want to use all these fancy words about, well, it wasn't polling, it was this, it was that. You know, if it looks like a skunk and smells like a skunk, it's a skunk. So long story short, the court at the end of the hearing asked a couple of great questions. You know, what's stopping a city board from creating a laundry list of competing proposals in its agenda item and then whittling them down? That's exactly what they did in this case. Why poll all the board members when you only need 4 are required to remove an item? They polled all 7. And so, although he asked, you might have to come up here, Kevin. But maybe not. While the judge asked great questions, he ruled that the city had the ability and the right to control their agenda. So he ruled against us the next day in a written order. And I'm going to try this one more time. This is where I need that. Kevin, you might make your way up here. I'm probably going to lose it again if you've got a minute. So he raised great questions. Professor Steinbuck gave an awesome closing argument about the rationale behind FOIA. But the judge ruled against us. Agenda formation, he put in his order. Agenda formation is authorized. I think I got it here, Kevin. Sorry about that. Agenda formation is authorized by Arkansas statute. the Arkansas legislature had granted municipalities the ability to manage their affairs through the adoption of resolutions and ordinance dealing with board agendas. The city of Fort Smith has accordingly adopted an ordinance and allowing for the removal of business. And then he goes on to say they did not violate FOIA. Well, long story short, we've appealed this case to our appellate, and we think it's going to be an important decision. The only question I have is it going to get to the Supreme Court before we ask the legislature to do their job and say that you cannot usurp FOIA by setting your agenda. You cannot do this polling on two competing items that we do not have the right to see. So you might think that's the end of the story, but I want to talk a little bit more about transparency here. What's the value of lawsuits? So kind of a timeline, because it feels like what's happened here is while we lost the lawsuit, and I think we're going to win on appeal, we've won on the transparency front. And here's the reason I say that. After we filed the lawsuit, about a week later, we held a press conference. Western Arkansas Transparency and Government Group and Citizens Against Unfair Taxation. We held a press conference. And we pointed out why it was wrong what the board had done. That they trying to jam this down our throats. We had no public input, no public discussion. They want to extend this tax 20 years. I mean, a tax for 20 years, you know, without one single comment by a board member about, well, what about 10 years? What about 5 years? So we pointed some of those things out. The judge makes his ruling, and then about 4 days later after the hearing, the board requests a study session to discuss the February 8th special election that they had passed this ordinance. And one, in our lawsuit, we had asked that the court strike the special election date, ruled against us on that issue. On December 21st, they had their special meeting. They listened to us, and they voted to stop the February 8th election. We've had various other meetings, and what they have agreed to do is to do several things. Number one, they agreed that there would be set up a special sales tax advisory committee with citizens being on that, who would get all the information on the tax, seeing how much was coming in, what they were spending it on. So that was a win for transparency. They also agreed through pressure of the Western Arkansas Transparency Group and others to shorten the period on both of these taxes to 8 years. We went from 20 down to 8. We went from 10 down to 8 on the other side. So that was a win. They agreed to put a freeze on sales tax. They agreed to put a freeze on raising our sewer rates. We had historic raises over the last several years in Fort Smith. They agreed to freeze the rates for 3 years, and anything past that, they would not raise rates for our citizens any more than 3.5 years. So they're listening. We've got their attention, and we're having this dialogue. And I think it's all because of citizens like yourselves who got involved. Many citizens across Fort Smith got involved and said, look, we've got to do our business in a transparent manner, in an open manner. So that's that case. Now I want to kind of shift gears and talk, I think Ellen Kreth, who is the Madison County Record, she writes for the Madison County Record, is going to talk some about a case that is in Huntsville, which involves some sexual abuse against some minor students in that school system. I've been involved in 2 cases. One of them that I'm going to talk today is a FOIA case in which we alleged and got a court order on various Freedom of Information Act violations within the Huntsville School District. I think one of the things I want to say is many times that these FOIA issues come up on major issues that affect our lives, whether it's taxes, whether it's abuse of minors, whether it's in Jonesboro, that I'm going to talk briefly about that case. In Jonesboro, Arkansas, the library having vulgar and what I would information on the library shelves. I mean, just all kinds of various issues. But Ben Reitzel was again, a concerned citizen in Huntsville. We filed this lawsuit on his behalf. We spent another day in court, all day before Judge Martin, and we now have an agreed order. There were a couple of issues that they did not agree to that we tried to the court, but the agreed order. Yeah, Kevin, we can turn those lights back on if you'd like. In essence, we found over 10 violations of the Freedom of Information Act that involved this issue. The first one we found involved disciplinary hearings of students in which they did not give notice to the public, just like we were talking about earlier. If you had asked to get notice along with the media, then the media should have gotten notice of this. They did not. A violation. We passed a law in 2017. Senator Sullivan was involved in that as a member of I think you were a state representative at that point, which requires that all public meetings be recorded. And thank you for that. That is a law that is so important. I talked about it a minute ago when I was able to go back and look at the video, and we have board members stating, we're no longer guessing about what they said. We know exactly what they said and how they said it. Michael Comet's back here running for mayor of Centerton. We had we just tried a lawsuit on his behalf. Won that lawsuit, open records violation, but again, in the meeting we went to, are you recording this? Yes, we are. So they had various other instances of special meetings for the purpose of hearing recommended discipline of students. Again, no notice to the media, no recordings, or they say they recorded it, but they didn't keep the recording. You're required to keep the recording for half a year. They had a training session, same violations. Then we found, through FOIA, we found a series of text messages where board members were texting each other regarding the COVID crisis. They're doing our public business. They're text messaging each other about what to do on the COVID crisis with regard to our students. Because the law is in such a state of flux now regarding open meetings, while they would not admit that that was a violation, they did admit that they would not do it again. So that's why we want a clarification on the law. We got into a tussle with them over various text messages that we received. They claimed that they were protected by FERPA, which protects students' rights of privacy, which we believe is very important, and the Arkansas Child Maltreatment Act. They made the claim that these text messages, if they gave them to us, they violated FOIA. Problem for them being is they had already given the same documents to the news media. Every document we asked for, they had already given it to the local news media. So we just said, we want the document. Long story short, the judge ruled in our favor on that. There were various text messages that had nothing to do with student privacy. The judge has ordered them to produce those. It was another violation of FOIA. In all of these orders, I insist that they get training. The judge in this case ordered training. You know, again, you see the history here. I mean, 10 violations of FOIA. So what do they do on the training? On day 61, Ellen Kreth calls up the superintendent and asks if you've had the training, and she says, "What training?" And, well, the court order says you're supposed to get trained. So the next night, I guess the lawyer fesses up and says, well, I don't think I told the superintendent that they were court ordered to have training. So we're going to have it tonight at the school board meeting. So, you know, they spend little, if any, time. I think it was 45 minutes and, you know, get some training. But, you know, government has to understand how important the Freedom of Information Act is. I mean, you know, where we're dealing with massive tax dollars or we're dealing with abuse of children, you know, our ability, our right to know is so important. Okay, I think I've got a couple of more minutes. I'm going to cover very briefly another series of cases that we filed in Jonesboro, Arkansas. We got Bob Hester here today. I've known Bob for many years. We've worked together on many issues. A credit to Jonesboro, Arkansas. I mean, Bob just knows what's going on, and we appreciate you, Bob, and thanks for coming over today. We filed a lawsuit for Amanda Eskew. What had happened was there were several books in the children's section that she felt like were in the Jonesboro Craighead Library that were harmful to minors and contained nudity, although, you know, they argued that point. No matter what you feel about it, I know that the local, I said, you know, if you have any doubt about whether these are pornographic in nature, then here's what we'll agree to this interview, but we just want to hold up a picture of what the content is. After seeing the content, they declined to put the content up. But long story short, this was a FOIA case where she made a proposal to the board to create a review process and allow the board to make recommendations. Subsequently, there was a sensitive content subcommittee formed by the Jonesboro Public Library. Well, long story short, they met, this sensitive subcommittee met, violated FOIA, did not give notice to the media. I mean, clear and simple. I mean, give notice so that the public can come see what you're talking about. We filed suit. They immediately, you know, after, for lack of a better word, trash-talking my client, agreed that they violated FOIA and they would pay her attorney fees. And, you know, it's just, you know, I guess I would just call it, sometimes government bodies are just arrogant, and you know, and you've got to break them of that habit, and sometimes a lawsuit's the way to do that. Not to be outdone, however, several weeks later, the same Jonesboro Public Library refused to provide records to a local Jonesboro citizen. And not only that, they altered records that they provided, the back of a check. And so we filed suit, and, you know, again, they immediately agreed that they violated FOIA by not providing these documents and agreed to pay attorney fees. But, you know, it's so sometimes you have to file a lawsuit and to show that, you know, we mean business and our rights are not for sale. Colonel Parsons is one of my heroes, Colonel Jim Parsons. He has fought battle after battle, and speaking of attorney fees, Colonel Parsons was ordered to pay, I don't know, Colonel Parsons, $10,000 in attorney fees for a case that he brought as a pro se plaintiff, which was frankly just wrong. But Colonel Parsons is fighting for the rights of everyday people, and I'm so appreciative of him. Bob Gregory is also in the room. We've mentioned various FOIA freedom fighters. If you haven't had a chance to go to the Faulkner County reports, please do so. Bob is fighting the transparency battles and has an absolutely awesome website, the Faulkner County Reports, in which he tracks county government in Conway. Bob and I went down the lawsuit. We filed a lawsuit. I guess it's been a couple of 3 years ago now. I think that was a record request that they just kind of thumbed their nose at Bob. We filed suit again, an agreed order. And they admitted they violated FOIA. I wish we had more teeth in FOIA. I think that's something that various legislators have talked about. But anyway, that's kind of from a perspective of a lawyer and how the judicial process should work. And I think with that said, any questions? If you have any questions, we're happy to answer any questions. I think that's sometimes the best part of the process.